Hi, everyone. Welcome to the 5th annual Human Rights in the Field lecture sponsored by Towson University's History Department and the Human Rights and History minor. I appreciate the faculty who are here and who have encouraged their students to come. I think we might be anticipating the dean at some point, so shout out to those folks who are coming. And of course, that is gives us some understanding of the recognition people have to the importance of tonight's discussion. I'm glad folks have encouraged their students to attend. So welcome especially to the students and to our guests on Zoom. So in person and Zoom, we're happy to have you, and this will be recorded and we'll post it in the event that you have other students or you have friends who might want to catch this later on. The Human Rights and History minor hosts 2 annual lectures that reflect the 2 main components of the Human Rights and History minor, and one of them is academics and one of them is practical experience. As far as the previous lectures on the practical side, we have invited practitioners to talk about human rights for Uyghurs in China. We've talked about climate displacement, about international humanitarian aid in the Red Cross, and last year we invited a speaker from Human Rights Watch, the preeminent human rights organization based in the United States, to answer the question of whether human rights matter in light of what was happening in Gaza and Israel. All of those topics generated a great deal of interest among our students, and I think that tonight's topic will be equally compelling as it asks us to turn our attention to matters much closer to home. Our annual Human Rights in the Field lecture focuses on this practical experience that the minor aims to give students in the program. So we bring practitioners to demonstrate possible professional opportunities for students who study human rights and history by presenting a topic related to their field of interest. So I think the speaker will offer some information about the path to move forward if this is your field of interest before he finishes his comments tonight. I also want to mention that our program has a second lecture series. That's the annual Human Rights and History lecture, which brings scholars to speak to students in the campus community about their scholarship on human rights topics. We have a very engaging and timely topic planned for the 7th annual Human Rights and History lecture, which will take place on April 8th. So follow us on Instagram, @TU_Human Rights History, or look for our flyers on campus on the screens, or check out the Human Rights and History website for information on that lecture next semester. And for those of you in person or online, if you're a student and you want to learn more about the Human Rights and History minor, particularly as registration is right around the corner for next semester, please reach out to me or stop by next Monday at the entryway in the College of Liberal Arts on the 2nd floor, where I will be tabling from 10 to 12 to talk to students about the History Department's programs, including the Human Rights and History minor. Our speaker, Jonathan Smith, is well positioned to address the topic 1960s civil rights legislation then and now, social movements, legislatures, and courts, which is the title of his lecture. I was planning to share his bio with you, but he informs me that he's going to give it to you along the way. So I'm going to leave it up to him to do that now, but please join me in welcoming our speaker.
Thank you. It's a real honor to be here, and thank you everybody for turning out, and I hope that I can contribute to the conversation around these important topics in the lecture. Oh, am I not on?
Can you hear her back there?
Can you hear the microphone on?
I think we can hear him.
Okay. Sometimes my voice drops. If it does and you can't hear me, please let me know. I want to start talking tonight a little bit with a confession that this was a particularly difficult lecture for me to try to prepare and to write. I think I probably got about a dozen versions of the outline that I started and abandoned. A year ago, I would have wanted to spend some time with you tonight discussing the evolution of the legal civil rights movement, unaddressed challenges, and my thoughts about the path forward. But we're at an incredibly important inflection point in our history. And this is true across many domains, but it's particularly true in the area of civil rights. When I started practicing law 40 years ago, I thought that progress towards equity and justice was inevitable, and that the legacy of discrimination was moved towards elimination. No doubt there'll be moments of challenge, backsliding, but history would drive us towards greater equity and justice. In 2020, after the murder of George Floyd and Breonna Taylor, it appeared that we would take another major step forward in the march towards racial justice. As a nation, we confronted truths about our history and how history shaped who we are today. But progress no longer seems inevitable. And so much that was so hard fought is it has been lost or is at risk. The retreat from principles of fairness and justice over the last 10 months are so swift and so profound that I am beginning to no longer recognize America as an imperfect nation that can grow closer to its founding ideals. With each passing day, each new assault on our rights, I fall deeper in despair for the nation. I try to remember that the civil rights struggle has always been hard. Leaders of the movement fought and struggled during times of racial terrorism, when bombings and lynchings were the norm. I try not to forget that when John Lewis crossed the crest of the Edmund Pettus Bridge, the Voting Rights Act was not inevitable. His bravery and everyone who marched with him made it an inevitability. John Lewis's bravery and the bravery of millions of other activists over the years remind me that even when justice appears impossible, beyond our reach, even in those moments when we find ourselves today, if we stand together, we can move forward towards a more perfect union. There's much to unpack about how we got to this moment in history, and I have neither the expertise nor the time to discuss that entire subject. Instead, I want to spend my time with you this evening talking about the critical fight we have to preserve civil rights. This afternoon, I want to try to address 4 basic points. 1, the rights we are losing matter and should be protected. They've made a difference in the lives of millions of Americans. We have not fully addressed racial inequity and forms of discrimination, but these laws have made a difference. 2, the rights will not be saved in the courtroom alone. We need a political struggle along with a legal one. 3, the narrative matters. Policy and laws based on are based on the narratives that we tell. We need not to be shy about telling the truth of inequity and meeting the narratives that are eroding our rights. And 4, efforts to address unequal access to opportunity and discrimination need to be more dynamic. It is essential that we meet the moment with the seriousness and determination that it deserves. We need policies and laws that can face challenges and challenging times and conditions. Oppression is relentless and creative, so must be our response. As noted, I'm not an academic, and I'm here as a practicing lawyer. And I don't want to dwell long on my background, but I want to give you a brief description of who I am so you know the perspective that I'm coming from. More than 40 years, I've practiced law at the intersection between race, poverty, and our criminal legal system. I graduated from the Antioch School of Law in 1984 and joined a small civil rights firm in Alexandria, Virginia, where practice largely focused on prison and jail conditions, police misconduct, employment discrimination, housing discrimination, and representing persons who are engaged in civil disobedience and demonstrators. I left that practice after 5 years to help start a nonprofit in District of Columbia that represented prisoners in the District of prison system, where I stayed for 9 years until the district's prison system was federalized. Recognizing that the most powerful way to address prison conditions, was to change the social conditions that led to economic inequality that drove incarceration, I turned my practice to economic justice, where I worked first at the Public Justice Center in Baltimore, and then was the executive director of the DC Legal Aid Society in District. Barack Obama was elected as president, and I was recruited to join the Civil Rights Division of the United States Department of Justice, where I led the Special Investigation Section. We were responsible for the investigation of police departments, prisons, jails, mental health institutions, and other state-run institutions where people were confined. I worked on more than 20 police investigations there, with the final one being the investigation of the police department of Ferguson, Missouri, after the death of Michael Brown. After that, I spent a brief period of time at the UDC David A. Clark School of Law, became the executive director of the Washington Lawyers Committee for Civil Rights and Urban Affairs, And in January of 2021, I was hired by Attorney General Anthony Brown to open up the Civil Rights Division of the Office of the Attorney General here in Maryland, where we bring a broad range of civil rights cases across the state. Throughout my career, and through the range of areas in which I practiced, the honored to practice law, I have seen that the rights embedded in the Civil Rights Act matter. To place the Civil Rights Act in context, it's helpful to recall briefly the events that led up to the enactment of the Civil Rights Act in the 1960s. It was a period of tremendous social unrest. The regime of Jim Crow had formed the architecture of racial relations since the end of the Civil War was coming to an end. The Great Migration North and the nonviolent protest movement had chipped away at the foundation of that form of a racial caste system. Resistance had begun to take on many forms. Throughout the South, in particular here, and notably here in Baltimore, young Black people sat in at white-only lunch counters to challenge racial segregation. One such protest was led by none other than recently retired Supreme Court Justice Robert Bell. Judge Bell was just 15 years old and a high school student when he was arrested at the Reed Drugstore in downtown Baltimore. Judge Bell case was litigated all the way to the United States Supreme Court in the landmark case of Bell versus Maryland, and Judge Bell went on to be the only person who's ever served in every position in our court system, from the district court, circuit court, court of special appeals, the Maryland Supreme Court, and then the Chief Justice of the Supreme Court. Rosa Parks inspired the bus boycott. Black sanitation workers went on strike in Memphis, Tennessee. And then there was the Children's March in Birmingham, where thousands of young people, from small children to high school students, faced the dogs and fire hoses of Bull Connor. And it was the showing of those photographs and those videos on the front pages of newspapers across the country and on the evening news that catalyzed the support of Lyndon Johnson for the Civil Rights Act. And then, of course, there was John Lewis's bravery facing the Alabama State Police as he crossed the Edmund Pettus Bridge that catalyzed support for the Voting Rights Act. These okay, better?
Much.
Okay, sorry about that.
Apologies.
These sentinel events, get a bit of an echo. These sentinel events were critical, but happened against the backdrop of decades of organizing in kitchens, in church basements, in union halls across the nation. They were the acts of heroism that ended up on our history books, but they're against the backdrops of millions of people engaging in small and large acts of heroism that we don't read about. In 1964, the United States Congress enacted the Civil Rights Act. In 1965, the Voting Rights Act. In 1968, the Fair Housing Act.
Repeat that?
Sure. In 1964, Congress enacted the Civil Rights Act, followed by the Voting Rights Act in 1965. And then in 1968, Congress enacted the Fair Housing Act. Interesting history there. We'll off my notes here. Interesting history there about why it took 4 more years to enact the Fair Housing Act. If you read the debate in Congress, Congress was willing to, in the South, and Southern senators were willing to agree that we should prohibit discrimination in qualifications, even in voting. But residential housing segregation is such a powerful tool of maintaining separation of the races, that it took 4 more years to get the Fair Housing Act. It was originally in the original act and it was taken out of the original act. Most interestingly, in terms of the enactment of the law, if you go back and read the record, the gender was actually not in the original 1964 act. And as an effort to try to kill the Civil Rights Act, a Southern senator put gender in, thinking it was a poison pill. And it was the then 14 women in Congress, the entire Congress had 14 women, organized and kept gender in the statute when it passed. So if by happy accident, gender ended up in the Civil Rights Act. I think that it's, when we think about that moment and when those laws were passed, returning back to think about what the purpose of those laws were. And I want to just read for you a little bit about what Lyndon Johnson said at the signing of the Fair Housing Act. Lyndon Johnson said, in the Civil Rights Act of 1964, we affirm through law that men equal under God are also equal when they seek a job, when they get a meal in a restaurant, when they seek lodging for any night in any state union. Now the Negro family no longer suffers the humiliation of being turned away because of their race. In the Civil Rights Act of 1965, we affirm through law for every citizen in this land the most basic right of democracy, the right of the citizen to vote in an election in his country. In the 5 states where the act has its greatest impact, Negro voter registration has already more than doubled. Now this bill, this is the Fair Housing Act, the voice of justice speaks again. It proclaims that fair housing for all human beings who live in this country, is now part of the American way of life. At that moment may seem for many people in this room like ancient history, but for millions of Americans, it was within our lifetime. And it was clear at that moment that those laws were passed to address centuries of harms that were created by slavery and Jim Crow and other forms of racial oppression. And as I discuss more later, the legacy of racial and other forms of oppression continues to create inequality and mandates different outcomes for people based on their race and other characteristics. Nevertheless, the contrast between the objectives of the civil rights laws, when they were enacted, and the current political climate is just jarring. 60 years after the passage of the civil rights laws, we have a president who has issued executive order after executive order tackling civil rights laws, ending programs designed to address the history of racial oppression and fanning the flames of white victimhood. The Equal Employment Opportunities Commission has abandoned the use of disparate impact, which is one of the most powerful tools to address race discrimination. The Department of Housing and Urban Development has followed suit and is taking steps to limit the effect of the Fair Housing Act. And the United States Department of Justice's Civil Rights Division has been effectively decimated. And the Resources Department have been arrayed with overturned longstanding civil rights precedents. And finally, and disturbingly, the Supreme Court is poised to overturn the remaining portions of the Voting Rights Act. How did we get from a moment in history when our legal system was poised to address a long and shameful legacy of racial injustice to today, when the courts and the levers of government power are aligned to preserve a status quo of inequality, inequity, and injustice? A key goal of the Civil Rights Act was to end discrimination and embed in the law the creation of equal opportunity. The project to outlaw discrimination was a success, but it is also clear that the project remains incomplete. Brown versus Board of Education ended legal, separate, and unequal, but more than 60 years after the decision in Brown, the public schools remain as segregated today as the day that Brown versus Board was decided. Residential housing segregation has been outlawed, but access to housing remains a serious barrier for Black tenants, and Black homeownership, a primary source of intergenerational wealth, lags far behind white homeownership. Income inequality is persistent. For example, the average Black family in the state of Maryland has an annual income of about $79,000, and the average white family has an average income of $110,000, and the disparities in Maryland are some of the smallest in the nation. On average, a white Maryland family has accumulated 8 times the family wealth as the average Maryland Black family. Despite laws against racial discrimination and employment, the poverty rate in Maryland in Black community is 13.6%, which is more than twice the poverty rate in the white community. Black residents of Maryland are more likely to be unemployed, incarcerated, and housing insecure. The last case I worked on when I was at the Department of Justice was the investigation of the police department in Ferguson, Missouri. We opened our investigation after the death of Michael Brown and and after the community protests that had took place in Ferguson. Ferguson was a microcosm of the nation and illustrates what work is left to be done by the civil rights laws. Our investigation found profound problems with the operation of the police department and particularly with the municipal court. The police and the court were structured to target the Black community with excessive fines as a form of taxation that was crippling that community. This was happening against the backdrop of profound racial segregation. The town was more than 60% Black, yet this town government was 100% Black. The Black community lived almost exclusively in garden-style rental apartments, and the white community lived almost exclusively in single-family homes that they owned. They lived in entirely separate communities. Until the 1960s, Ferguson was a sundown town, which meant that a Black person could not be on the street after sundown unless they were in the presence of their employer. When I met with the mayor and the chief of police for the first time, as we opened up the investigation, they described the Black community that was dangerous and violent. The mayor was in his 30s and he'd grown up in Ferguson, Missouri, and he'd gone to his public schools there. And he told us a story during that meeting that when he would ride the bus to school and then went past the Black community, he would duck down below the windows because he was afraid of getting shot. There is no evidence that anyone ever shot at a school bus in Ferguson, Missouri. This comment and other comments made in that first meeting demonstrated the deep chasm between the perception and the reality of Ferguson's Black community. When I visited those apartment complexes, they were vibrant and resilient communities. Communities, then they were very different than what I had come to expect. They were communities that had experienced underinvestments, but where people had built lives and raised their families. The segregation wasn't just residential. Despite Ferguson being a small town, about 17,000 people, the school district lines were drawn so that Black students went to one school and all the white students went to another school. The school that Michael Brown attended was so broken that it was decertified by the state of Missouri. And rather than have the Black students go to the white school that was right there in Ferguson, they bused them an hour away while the school was being rebuilt. Notably, but where Michael Brown died was just 6 miles from the house that was the subject of the Supreme Court case in Shelley versus Kramer. That was one of Thurgood Marshall's early victories in the United States Supreme Court. In that case, the United States Supreme Court said that restrictive covenants that said that you could not sell a property to a Black person or a Jewish person or any other non-white person, was declared to be unconstitutional. Anybody who's seen the play or the movie Raisin in the Sun, that play, that brilliant play is based upon that case in Ferguson, Missouri. And what was so striking was that you had this landmark civil rights decision around racial segregation happening just, within a very short distance from the kind of segregation that led to the death of Michael Brown and the conditions of Ferguson, Missouri. I think it's easy sometimes to dismiss the civil rights movement and civil rights laws as a failure because of the persistence of inequality. I think that's both factually wrong, because progress has been real even incomplete, but it also dishonors the sacrifice of many who have committed their lives with struggles. So right, heroes, Ashiro, risk sometimes their lives to create the conditions for the enactment of its laws. The laws that the civil rights movement fought for are critical, and they are still worth fighting. Let me tell you about some of the people I have seen helped by our civil rights laws. We talked a bit earlier about the Fair Housing Act. The Fair Housing Act protects against discrimination based on race. The United States Supreme Court found that a neutral policy that has a discriminatory effect without a legitimate business interest is a violation of the Fair Housing Act. Signs that say no Blacks or no Jews may rent here or may buy here are the thing of the past, but discrimination continues, and racial segregation in housing continues to be a persistent problem. But discrimination has taken on new forms. And one of those is discrimination against persons with a record of conviction. Given race bias in our criminal legal system, Black and brown people are far more likely to have a record than other person. It is well documented that rates of arrest and conviction have little to do with behavior. Whites and Blacks offend and violate our laws at very similar rates. The disparities that result in our criminal legal system are from law enforcement and prosecutorial practices and race bias that's deeply embedded in our system. Studies have also shown that a conviction record, except in very narrow band of circumstances, have very little to do with whether someone will be a good tenant. Policies that exclude someone with a criminal conviction have a disproportionate impact as a result of people of color. When I was at the Washington Lawyers Committee, we used that law to help a family avoid becoming unhoused. The family had lived in an apartment complex for years. They were good tenants, they paid their rent, they obeyed all of the rules. There was no complaints about their tenancy. And their family was growing, they were having another child, and they wanted a larger unit to live in. They applied for a large unit, they applied to transfer from the apartment they were in to another apartment, and a background check discovered a decades-old drug conviction, and they were not only denied the ability to move, but they were threatened with eviction. We sued and demonstrated that the landlord's policy had a discriminatory effect and had no legitimate business interest, and the landlord was forced to put into place a new tenant screening policy that was tied to recidivism data. This case not only saved their tenancy, kept them from becoming unhoused, but it put into place a policy that opened up housing opportunity for thousands of people who would otherwise be excluded. In another example, during the pandemic, Congress created the Payroll Protection Program. The law was intended to assist small businesses to survive during the pandemic. Black-owned businesses were disproportionately harmed by the pandemic. More than 440,000 Black businesses closed during the pandemic. That was 41% of Black businesses. 440,000 Black businesses closed in the pandemic. That was 440,000 Black businesses. Well, I'm sorry, 41% of Black businesses. By contrast, 17% of white small businesses closed. Payroll protection program was thus a critical lifeline to maintain those businesses. But the Small Business Administration, who administered the payroll protection program, put into place a policy that banned anyone with a felony conviction from being able to participate in the payroll protection program. Because of discrimination, as we talked about earlier, many people coming home from prison couldn't get employment and started their own small business as a way to be successful. In addition, the data shows that a person who has themselves as a returning citizen is much more likely to hire other returning citizens into their business than someone who's never been incarcerated. Thus, the effect of a loss of a small Black business owned by someone who had come home from prison had a profound effect on the ability of returning citizens to be successful. The policy of the Small Business Administration therefore disproportionately affected people of color. So we sued. One of the people we represented had a small electrical company because he couldn't get a job after being in prison, and a PPP loan would have saved his business. The court found that the rule was arbitrary and capricious and found in our favor and ordered that the Small Business Administration open up loans to people with criminal convictions. And millions of Black businesses had access to those loans. Don't have any data about how many people were able to take advantage of it, but we did make at least that opportunity available. This doesn't mean that the Small Business Administration was deprived of the opportunity to consider criminal record in making loans either for that program or loans. But the criminal record had to somehow relate to whether or not someone was likely to repay loans. So if someone had recently been convicted of embezzling or had been convicted of fraud, that might be taken into account in making a decision about whether to make the loan, because that was relevant to the ability to repay. Anyone, an ancient drug conviction or convictions unrelated to someone's ability to pay may have no different risk in terms of their ability to repay the loan than someone who had never encountered the criminal legal system. And as a result, you can see that despite the fact that these cases didn't get at structural inequity, We didn't change the sort of dynamics of our society. For the individuals who are impacted, it made a difference. So I think it's an important question to ask, why did these laws actually not accomplish what they intended to do, and what has happened? In my view, as powerful as the courts are as a tool alone, the courts are inadequate. To effectively bring about change, there must also be the social conditions that create the space for the law to work. For anybody who reads the legal journal, even sometimes the newspaper, there's much debate in legal circles about how to interpret our laws and the Constitution. There are arguments whether the Constitution became a fixed and unyielding document when it was signed, or as a living document to be read consistent with the current moment. Do we believe that our interpretation should be seen through the eyes of colonists, or do we subscribe to a notion of an evolving standard of existence? I suggest that if you step back from the doctrinal debate, it becomes clear that all judges at all courts read laws through their own experience and lenses, and that the lens is focused by their social conditions. Even for those who claim to be strict constructionalists, they cherry pick the historic data to reach the result that supports their own social views. The present day necessarily controls the legal interpretation. A good lawyer and strong arguments matter, but to prevail over the long haul, social movements must play a critical role. Let me give you an example that demonstrates on a small scale how social conditions and social pressure makes a difference. Most of the 1990s, as I said earlier, I litigated cases to address conditions in the prisons and jails of the district. During that time, I had the honor of representing a class of prisoners at the DC jail. The jail was the third jail that had been built in the District of Columbia. The first jail was built in 1838, exclusively to house people who had escaped slavery in the South in order to hold them to return them back to slavery. In 1875, a new jail had been built, which was largely built based on dungeons from Europe, and where it stood for almost 100 years. For those who are interested in the history of the suffragette movement, when the suffragettes were arrested on the front lawn of the White House, they were housed in that particular jail, and the letters coming out describing the horrifying conditions that Black prisoners experienced were telling. Current jail was built in 1971 after the courts found the old jail was unconstitutional. The old jail was constitutional. The time that I worked on the case started in 1971. I came onto the case in the early 1990s. I inherited the case from other lawyers. Was the height of the AIDS epidemic, and AIDS and tuberculosis was just rampant throughout our prison system. Much of our litigation focused on the failure to provide prisoners with health care, particularly prisoners with chronic diseases like AIDS. We were in front of an incredibly good judge, Judge William Bryan, Chief Judge of the District Court in the District of Columbia, first Black Chief Judge of any district court in the United States, who had heard the case for more than 20 years. He had had contempt hearing after contempt hearing. He had entered order after order, but nothing was changing. And nothing changed until there was actually a horrifying death with a public outcry. A 39-year-old prisoner with AIDS was housed at the jail. He received virtually no medical care, and his condition rapidly deteriorated. Ultimately, he was too sick to leave his bed. Guards brought his food tray into him every day. They left it beside his bed. They returned later and they removed the food tray. And this went on for about 8 days. Other prisoners began to protest the lack of care and attention to this prisoner. Eventually, they made such a fuss that the guards came into his cell, lifted him into a wheelchair. He couldn't sit up. So they took his feces and urine-stained sheet, tied him to the wheelchair, and wheeled him to the infirmary where he died. It was a cruel and painful death. Sadly, his death was not unique or unusual. The neglect he experienced was common. HIV deaths in the prison system were common. But the difference was that we paired our advocacy in the courtroom with public advocacy. We teamed up with AIDS activists, anybody old enough remembers ACT UP. We connected to ACT UP. And we held a protest outside the jail, which included a memorial service for the man who died. The protest made the front page of the Washington Post. And at that point, the judge ordered that the healthcare system be placed under receivership. The judge appointed his own doctor to run the healthcare system and gave him the power to make the changes that were necessary to prevent that from happening again without interference from corrections officials. That fix worked. It worked well for about 15 years till the receivership ended, and neglect and underfunding of the healthcare system has allowed the system to return to failure. This small scale example is mirrored in the broader movement for justice around our carceral system. The modern prisoners' rights movement can mark its foundings in the uprising at Attica in 1971. Overcrowding and guard violence led prisoners to seize control of the prison. The uprising was violently put down, and the nation was shocked. This marked a turning point in the willingness of courts to address prison conditions. Scores of lawsuits across the country sought to address the horrors that had happened behind bars. The cases made a critical difference in addressing some of the worst abuses, but the pressures of mass incarceration and the lack of a community outcry were ultimately made those cases unsuccessful in making prisons and jails safe. For decades, cases placed population caps in prisons and jails, eliminated some of the most grotesque abuses, closed old jails in favor of modern facilities. But legal efforts to ensure that incarceration was constitutional and not cruel was overwhelmed by pressures of mass incarceration. The politics of the war on crime, the criminalization of drugs, with many people behind bars, and prisons were packed beyond their capacity. And there was no social movement demanding change. In fact, the social conditions were just the opposite. Pressures on the courts to keep people locked up. Pressure was on the courts to keep people locked up, to keep us safe. The policy of mass incarceration and long prison sentences did not create public safety. But that's a conversation for another day. Happy to talk about it. Prison walls, however, worked very effectively to not only keep people inside, but keep us from observing the cruelty and the inhumanity of what was happening in those prisons. It's important to note that mass incarceration was not an accident. It didn't just happen. After Nixon, President Nixon, who was the architect of the war on drugs and the war on crime, which led to mass incarceration in office, his lieutenant John Arrowcliffe was interviewed, and he noted, giving me a minute to give the quote, he's noted that said that Nixon campaign in 1968 and the Nixon White House after that had two enemies. The enemy were left and black people. You understand what I'm saying? We knew we couldn't make it illegal to be either against the war or black. But by getting the public to associate the hippies with marijuana and blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night in the evening news. Did we know we were lying about drugs? Of course we did. We're seeing that same playbook today. Demonize people over and over again, regardless of the truth. Recognizing the courts are responsive to social conditions, the narrative we tell matters. In the present moment, we have seen certain segments of our community dehumanized. Trans people have been declared not to exist by our president. Or even if they do, they're either violent or predatory. Immigrants have been deemed as criminals and dangerous. Black and brown people and women who have achieved professional success are called DEI hires, despite their skills and hard work to get where they are and the enormous contributions that they make. These narratives are driving policy. By dehumanizing people, we create the conditions that allow us to deny them of their rights. The war on transgender people is an example. There's a relentless attack on transgender people. These attacks started with the opposition to trans people participating in college sports. It is important to remember that there are fewer than 10 transgender collegiate athletes. This is not a legitimate basis to deny the very existence. That is demagoguery. I represented a transgender person in 1985 who was fired from the federal government. The court found that that was illegal discrimination, forced the Postal Service to rehire her. I had my first transgender employee in 2000, in the early 2000s, and I never thought, here we are 25 years later, almost 40 years after the first time I will represent a transgender person, that we have a moment of federal policy refuses to recognize the very existence of transgender. Despite this regression, I think it's also important to note that there are positive examples of change. The struggle for same-sex marriage is one of them. It provides a model for how we can achieve the kinds of results that expand on people's rights. In the 1970s, before the 1970s, being gay ended careers and created social ostracization. The turning point came when gay activists rebelled in 1969 outside the Stonewall Inn, a gay bar in Greenwich Village, after it had been raided by police. The modern gay rights movement was formed by the 1990s. You had and the AIDS activists, you had activism that had greater acceptance, and increasingly sexual orientation was protected by law. I remember representing protesters at the Supreme Court when they heard the arguments in Lawrence versus Texas that overturned the sodomy laws in Texas that criminalized consensual conduct between adults. I'll never forget that particular day. I was serving as a legal representative, interacting between the protesters and the police, and that was during a period of time when there was great fear about AIDS and lack of knowledge. We knew a lot about AIDS, but people in power tended to be somewhat ignorant of it. And all of the Federal Protective Service officers who were at the Plaza Police put on those yellow gloves that you use to wash dishes, and the crowd started to chant, "Your shoes don't match your gloves," and went on and on. I will never forget that. It was like the best protest chant I ever had experience to remember. And then we got to June of 2015, and the Supreme Court declared same-sex marriage the law of the land. There's no way 2 years earlier anybody would have thought the Supreme Court would have found a constitutional right to same-sex marriage. And it wasn't an accident. That didn't just happen because the Supreme Court found in the way that it read our Constitution something that had changed. What had happened was that starting in 2003, targeting a court in Hawaii, which was sympathetic to the rights of gay people, and we're getting a decision in 2003 out of that court, which led to decisions in other states, Massachusetts, and District of Columbia, and other places, in targeting legislation. It normalized same-sex marriage so that by the time it made it to the Supreme Court, it was common across the land, and the Supreme Court ruled the way that it did. And that campaign, that thoughtful campaign, similar to the thoughtful campaign that the Thurgood Marshall had led to get Brown versus Board decided. And Brown didn't come out of nowhere. Brown versus Board wasn't the first case that was brought. It was the 12th or 15th case that was brought. A very careful campaign. We can see that progress can be made. So, but now we see that same-sex marriage is under threat. We see that protections based on gender identity, disability rights, and others are also under threat. So where do we go from here? As I come close to the end of the talk, I'm going to have some things to say. I want to kind of leave you with two critical thoughts. First, the struggle for racial justice and to protect civil rights is going to come and will be lost through a partnership between organizing and people must take to the streets. No King's movement was a good start, but it's far from enough. In other countries, if there were threats to their democracy the way we're facing them now, we'd have nationwide strikes and mass demonstrations. But we must not only organize to meet this crisis, but organize to sustain our work over time. The voices of those most impacted should be centered and should be heard. Our legal infrastructure will follow the rule. Good lawyering will change the laws and restore the progress of creating a legal regime to protect rights, but only if that is demanded by the broader society. Second, we need our laws to be able to evolve to meet the moment. Discrimination is not static, and our response should not be static as well. Remaining in the paradigm of the 1960s book deprives us the opportunity for more profound change and feeds the narratives of white groups. It is critical that we continue to understand the effects of the legacy of discrimination and target remedies to address those effects. For example, I am a believer that reparations has to be part of the solution. Compensation for harm committed is a well-established legal principle. It can be measured either by the benefit that the person creating the harm, the person causing the harm received, or by the cost to the person who was harmed. This can be a framework for thinking about reparations. I also recognize that part of the backlash we see today is because of the reparations. White Americans do not necessarily understand why they should pay for acts that happened 100 years ago. The problem finds its origin in part, I think, the fact that whites and blacks often live in two worlds. Whites and blacks often experience the impact of history very differently. The efforts of the federal government to whitewash our museums, our national parks, and history taught in our schools underscores the depth of racism that continues to control public policy. But I think there's another way to look at this that might persuade some people with goodwill who may not currently understand. If you haven't had a chance, there's a brilliant book by Professor Richard Rothstein called The Color of Law. I strongly recommend it. In the book, he documents the role that the government played in creating residential housing segregation. It's important to note that, and when you read the book, you'll see that many of the laws that were adopted across the country to create housing segregation were first piloted here in Baltimore, Maryland. Maryland was, in some ways, the origin of many of the Jim Crow laws that were populated throughout the state. One of the things that Professor Rothstein's book documents is the way that the federal government subsidized home ownership for whites and excluded blacks from access to credit and to subsidized loans in red money. As a result, millions of white Americans were able to buy homes at reduced cost, and those homes have accumulated equity that has created intergenerational wealth. Black families were denied that opportunity. Our laws are inadequate, currently inadequate to address the effects today on Black wealth of this historic discrimination. Doing so is not to punish white people. Its reparations are often painted, but is instead simply leveling the playing field by correcting historic wrong. Finally, I want to leave you with a call to action and words of hope. These are incredibly challenging times. We are not just at risk of losing the laws that protect our civil rights, but of democracy itself. We will only save democracy if each of us act with the same courage and determination as the warriors of the civil rights movement of the 1960s. They organized, they marched, they voted, they told the truth of segregation and discrimination. We too must do the same. Taking to the streets was an effective tool, and I suggest that it remains an effective tool. But technology has changed the world. As young people, you know far better than I do that there are a whole lot of other ways to influence public policy. Whatever way you choose to take action, whatever you think is most effective, now is the moment. We don't act now, we don't act soon, it may be too late. Like John Lewis, we cannot know that we will prevail. The outcome is hidden in the future. But I am confident if we act, even facing these hardships, we can make the nation live up to its ideals of equity and justice. Thank you.
We've all been enriched by those comments, and I'm sure you all have many, many questions. I've already heard there are some interest in the questions in the chat, so I'm gonna try to monitor that.
Sure.
But let's start with our folks in person here. Yes,
Based off the framework you mentioned earlier, what are some real world offers that you would make to the Black community in terms of reparations?
I'm sorry,
What-
are you,
Sorry,
the very
what
last bit
real-
of what you said, yeah.
Based off your framework that you mentioned earlier, what
Sure.
are some real world sorry, I keep reading the word reparations
Reparation, yeah.
that you would offer to the Black community?
So I think that there's sort of a couple of ways that's important to think about this. We should look to the places in which, to start, look to places in which government action has led to the discrimination. So while reparations should be paid by private actors, and you've seen across the country that some businesses and some universities and others have undertaken reparation programs. I think the most potent place to begin the conversation is around government. That's why sort of the focus about housing is such a good example. You have very specific deliberate government policy, which is designed to create inequality based upon race. And so looking at those places, access to education, access to funding. And so part of that would be, and I think the most controversial part of that is that it would be a check. And I think that that has to be on the table to be considered and talked about. But that is, I think, the most controversial part. But can we do things like, for example, could you create programs that created the opportunity for people to purchase housing at where they could accumulate equity had they been able to do that in the 1960s and 1970s that were excluded by that. So, do you have loan programs that are super low income? Do you subsidize people's purchase of those loans? Are there ways in which we can address that inequity that was created specifically by government policy? We think about the same way around creating opportunities around education. We saw here in Maryland for a long time that our HBCU system was dramatically underfunded compared to the rest of the university system. And there was decades of litigation before you created the kind of resources for HBCUs that they were entitled to. You could think about what does the reparations look like there as well? Would you, how do you create programs that create other opportunities? So I think that there's a lot of ability and there's a lot of space between write a big check and what we do now, which is to sort of say everybody's starting at the same starting line. We're just going to go from here as if nothing can happen. There's a lot of space in between in which we can do some work and do some thinking. I think the problem is that we're not really examining deeply for public consumption, but the sources of the inequality and the inequity where we are. And that's where we're going to get some solutions. You have this sort of dichotomy where the Reparations Commission in California, I think, is sort of a good example where they came out. Anybody who didn't read the 100 and some page report thinks that the top line was every Black person gets $5 million. How could that be fair? Right? And if you have to read the report to understand where that number came from and what people thought through it. So I think the part of value of reparations discussion is really actually sussing those things out. But I think that we should look for policies in places where we can actually put our thumb on the scale in a way that makes sense.
just want to come a little closer for the sake of the video.
Sorry.
Or just go in front here, because the camera is right
Yeah.
in that direction. And please, yes.
I think it would be in the state of planning, it would be ineffective motor protest. I'm aware that part of the reason the civil rights movement protests such as citizens and being so heavily televised is because of the uniqueness of it all. What do you think would be a good mode of protest in today's age?
So, I think that some of that has to come from the communities that are deeply impacted by this event. I think that there are lots of ways to have our voices heard. it is, and I think the most visible ways are the ones that are gonna have greatest impact. That's why mass demonstrations, I think, can make a big difference. People in the street doing things. You know, when you think about what happened, in Birmingham, the Children's March, and I know that people probably are very familiar with this, I don't wanna bore people with the history, but, you know, you had those kids self-organized. Dr. King had been there, and they had considered those demonstrations, and Dr. King had said, you know, it's too dangerous, we're not gonna put those kids on the front line. But those kids themselves, and with the support of Fred Shuttlesworth, the kids themselves organized and went to the church on that square. And they went out in you know, 50 groups of 50 each to face Bull Connor and those, the day after day after day, they crowded the jails. And that was very powerful, both because of the image, but because of the certitude that those young people had about why this was critically important. That's what comes across. So it has to be the authentic response of people seeking their own liberation, and for all of us to support, and allies to support that. And so, you know, I'm not an online person. I am reluctantly on LinkedIn and no other social media. So I'm just too old, right? But I know that amazing things are happening online in terms of organizing and influencing and changing the way people think. So that might be the right way for people to do it. For us old folks, going out on the street might be the right way to do it. You know, my wife writes letters for every election. She writes letters to people that are given to her that are likely voters that might not vote. You know, so there's different ways people will do it, but it's important that all of us do it, and we do it visibly. You probably know better what young people are going to think is the way that they can have an influence and make a difference. But the important thing I want to say is you have that power. And that is really critical. I think it's so easy to feel disempowered at this moment, especially, you know, every day we turn on the news, we turn, you know, my news feed, and it's like, I get incredibly depressed because what I was worried about yesterday has now been overshadowed by what I'm worried about today, and tomorrow is just going to be worse. And we can't be defeated that way. We have to be able to respond. And so people should do it in their own way. But I think that we need to do it loud, and we need to do it visibly, and we need to do it is in the ways that we're going to be heard. We need to bring our friends along, we need to bring our family along, and we need to talk truth about what's really going on in this country, who's harmed and who isn't harmed by these policies.
That's right.
So I know that at Towson University, in a lot of other states in Maryland, we are required to purchase our furniture for dorms and classrooms from the Maryland Correctional Institution in prison place. And I also know that a lot of license plates are made there. I was wondering, as an employer, I think, how is this system set up? Does it happen in other areas? Has it been protested, been successful? And if so, how can we fix it?
Yeah, so it's a really good question. It's what Maryland does is replicated across the country. There are a few exceptions, which I'll try to mention. The prison industries of one sort or another are very common. They're seen as programs to provide skills training and work for people while they're incarcerated. Prisoners get paid pennies for the work that they do. You know, it's not an opportunity for people to actually earn income or to support their families or whatever. I'm a strong believer, and part of that goes back, there's some laws around this that go back to the restrict what prisoners can and cannot do, that go back to what unions put in place in law in Florida would protect union jobs. And so there's certain things that prisoners will do and won't be able to do. And this is true in the federal system. There's prison industries in the federal system, and there's prison industry in most states. I'm a strong believer that prisoners should be paid the prevailing wage, and that you ought to be able to create the opportunity for people to save that income to support their families and for their reentry back into society. When you leave prison, very often you're destitute, but while you're in prison, it's extremely expensive for the families. If you wanna make a phone call in most prison systems, it costs a lot of money. It can cost, in some places, $10 or $15 just simply to have a phone call with your loved ones. And that cost is borne by the families because prisoners are not earning income while they're incarcerated. And data shows us that it most disproportionately falls on women of color who are the head of the families while their loved one is locked up. And so it essentially drains out of Black families, mostly Black families, income into the prison system. And so I think you feel the opportunity to create income while they're locked up is hugely important for a whole range of reasons. There are a couple of places in which you've got some exceptions to what the general practice of essentially slave labor. And we know under the 13th Amendment, you can't force anybody to work and under indentured servitude or slavery conditions, except for prisoners. The 13th Amendment carves out prisoners. And that's how they get away with these kinds of violations of people's wages and laws. And you can punish people for their work and all that sort of stuff. In Maine, interestingly enough, Maine is an oddly progressive prison system. They're one of the first states that allowed prisoners to vote when they're locked up. And there's always 1 or 2 prisoners to run for governor every year from Thomaston Prison on the coast of Maine. They never get more than a couple hundred votes, but they get a couple hundred votes, mostly because people that they're locked up with. They actually have a system where prisoners can make furniture that is then sold, and after the costs of the wood and the supplies or whatever is deducted, the money goes to the prisoner who made the piece of furniture. And that's a model that I think can make a lot of sense because it gives people skills. It's an entrepreneurial kind of thing. So I think that there are some places where people are starting to think differently about this, but it is a real problem. Prison labor is a real problem. It's great for people to have something to do. Activity is great. Skills development is great. But the way in which having a loved one in prison impoverishes the family is a real problem. And this is a partial solution to it.
Other questions? Sorry, yes, I'm sorry.
So, going off of, the question about protests and, how to approach these things, my question is, we see all of our rights being, targeted at the same time. And yet, the way we are protesting is very siloed. Do you think there are ways that we can figure out that our freedoms are equally important, and if one is attacked, the other is tied to it? It's a collective effort that we have to make, and there is strength in numbers that way. Is there a possibility that we can educate each other and ourselves as to how these things are interconnected and our causes intertwined?
So I think that is a critically important problem of the response to the current law, is that we don't see our collective humanity and our ability and what and the effect that it has on each of us. And the current administration has been very careful to target in a particular way and create the conditions by targeting particularly trans people and immigrants, groups that for whom there aren't large coalitions of support. It's a very clever strategy, and that is that has been the justification, for example, particularly immigrant immigration. We're setting up a situation where we're sending National Guard into cities across the country. I don't think National Guard, personally, I don't think National Guard has anything to do with immigration enforcement right now. I think it is about to normalize the use of Guard to suppress dissent and to interfere with the 2026 election. I know that's a pretty extreme statement, but I think it is true. It is to normalize those behaviors. And we all have to see the effect that that's happening. So when the Guard comes into a city and suppresses dissent, That's not just dissent around immigration. That's dissent around everybody's liberation and everybody's ability to have this. And so I think that's critically important. One of the things I despair about this moment is the lack of leadership. When we think about what the civil rights movement, we think of other movements, we think about the LGBTQ movement, women's movement, Cesar Chavez and the movement around unionization of agricultural workers, or whatever. There has been these seminal leaders. When you think about, you had, Dr. King, Kwame Ture, Fred Shuttlesworth, this cast of Coretta Scott King, this, this extraordinary group of leaders at that moment. And for reasons that I can't sort of fully grasp, it's been a long time since we've catalyzed that kind of leadership and been able to bring together those coalitions. And remember, Dr. King was moving away from just an analysis of what was going on in this country around racial segregation towards one of thinking about what is economic rights and peace. And he was bringing those coalitions together. He would have stood, he'd been long enough for Cesar Chavez in California. He would have, fought for, I don't know where he would have been on gay rights, but he would have supported women's liberation. Might have taken him a while to get there, but he would have eventually supported women's liberation. And that's the kind of leadership that we don't really have right now. And can't tell you exactly why or where that leadership's going to come from, but it's going to be critical to pull us all together and recognize each other's humanity and to be able to do that. Thank you.
Because you are for a living constitution, are you worried that this administration could abuse that to say maybe extend their term limits? Or
So-
other areas?
So I don't think, I think there's gonna be another Bruce. I don't know that they'll actually, that Trump will be on the top of the ballot next election in 2028. What they've been talking about is that they flip the ticket, they put Vance as the presidential candidate, Trump was the vice presidential candidate, and Trump resigns. Then Vance resigns on the day of inauguration. I don't know whether that's gonna happen. I do think this is quite frightening that this has now become conversation. One of the things we've learned about this administration is that they don't muse about anything. They tell us, we gotta believe them. They tell us what they're gonna do, and then they set out to do it. And so I am concerned about what the thinking here is, whether it's right now we're seeing already indications of interference with the 2026 election. We've got, even in this off-cycle elections, we're seeing federal interference, the collection of voter rolls from every state around the country, the intimidation of voting officials in states around the country, particularly states that are Democratic states. This effort to try to redistrict, it's just horrifying. Candidly, it's horrifying on both sides, but I guess I don't know what the response should be if it's not what it is. All of that indicates to us that our ability to have our voices heard through the electoral process is going to be a little bit. I think that's a more likely result, and they'll actually have a Trump Vance 2028 ticket and just ignore the Constitution.
I think we have a question that comes from the chat, but is gonna be read by,
I think there's something
Is it-
different
is
in the
it-
chat maybe, but our the vice president of OIIE has a question.
here it is, okay.
Maybe
Shall
maybe it's a different one, because she asked me this separately.
Affirmative action?
No,
Okay.
so what she has asked here is getting in good trouble, which is protest, essentially, has consequences. How can we protest and still protect our higher education institutions from the unlawful withholding of funds?
I don't know that there's anything we can do that doesn't have risk right now. Saying nothing carries risk. Doing something carries risk. And that's unfortunately the moment that we live in. There's no safe path forward. If we allow interference with our higher education institutions to provide an education with a diversity of viewpoints, and we narrow the viewpoints that are available for higher education. And we allow it to become a propaganda tool for a specific point of view. Then there's an enormous danger for us as a culture and as a society going forward. If we stand up to that, we've seen what happens. We see the retribution that comes out of this administration. The only way I can see that there's any safety at all is if everybody stands together. And, you know, when you start to lose one here and one there and people, that's when, I think that is one of the greatest hazards. If everybody says no, we can stand together and say no. It's the conceding of some, the efforts to try to accommodate, to think this is gonna be less bad than the result. That's where the hazard lies, but I don't think there's any way to avoid the risk. I think the risk is there no matter what we do.
Yeah, one more question.
Yeah, sorry, one more question.
No,
So how would you react to the California government's reaction to the Texan government redlining? Like, would you say that's an appropriate reaction, the best reaction, or?
The redistricting?
Yes, sorry.
Yeah, I think that California's been forced into a corner, the states, the Democratic states that are redistricting forced into a corner. I have long been, a person who strongly believed we should have commissions that did this, that, were bipartisan and independent and, didn't have this, either political gerrymandering or, racial gerrymandering was, taken off the table. But I don't know what the option other than what California is doing and other democratic states is doing. They're doing it now. I think they've been forced into a corner by what happened in Texas and what's happening in states around the country. I think it's terrible, but I don't know that there's enough trust. So I think that maybe this is a moment in which everybody will, there's enough shock that of what this is going to yield, that we figure out a different path forward, when we go through this moment, figure out how to have a different way of apportioning our voting that protects the right of everybody to vote. But this is not a system that's going to ultimately protect the right of everybody. If you looked at these maps now, that if Supreme Court does what we expect it to do with regard to the Voting Rights Act, the number of Black majority districts that are going to be lost throughout the South is just profound. And it's going to really deprive people of the right to be able to elect officials that represent them in the way they want to represent. And so we're going to need to do something really significant once we get to this point.
one more question here, and then I want to take the last question and invite everybody to maybe talk a little bit more informally with our speaker. And I know there's some faculty out there, maybe students want to talk to as well. So the last question from Vice President Bradley, who asked this question earlier: affirmative action in employment and government contracts is a form of reparations. Executive orders, not laws, that have effectively ended all forms of affirmative action, not just in education. Do you think the challenges in court will be successful? And if not, is there a legislative recourse?
So, there's a lot to unpack with that question, and probably more than I have at the moment. But so affirmative action, there's been an attack that is much broader than affirmative action. It's affirmative action is a remedy under the law to address historic discrimination. So if you could show that bias has influenced the way the decisions in employment are being made, you can put into place affirmative action or education or other places to address that bias. And so, it is in that way, it's really a remedy almost more than it is a reparation. If we really think of reparations, you could have to go far beyond what affirmative action can provide. Executive orders don't stop it. They don't just prevent from correcting what we can prove is the discrimination that existed in the past. They've gone after programs that the whole demonization of diversity, equity, and inclusion is far broader than affirmative action. DEI is an effort to try to say that it's trying to create an environment where everybody is welcome and can be successful. And it's to think about what are the barriers for qualified people to be successful in our workplaces in our institutes of higher education. It is not somehow preferencing anybody. It's in fact going to benefit all of us. Because inclusion and the ability to be included is going to make us all more happy and successful and happy. And so this attack is really an attack on that goes way beyond that. It's really to support the maintenance of the hiring of white people. I mean, we've seen this, you know, the Civil Rights Division has opened up investigations because they think that the people who are most significantly harmed by discrimination in this country are white Christians. You know, it's like we've just turned the world on our head. And so I think that this goes way beyond affirmative action towards DEI. Executive orders, it is important. I don't think the court case is going to be successful. I think the Supreme Court is very clear. We're going to win in the lower courts and we're going to lose the Supreme Court. And I think that's going to be a problem. I think that we're going to have to figure out other ways to solve these kinds of problems. And I don't know that this is necessarily the fix the Supreme Court.
Okay, since it looks like a lot of students are having to move to the next thing, I want to invite everybody to a reception with our speaker, and I'll just leave you with the thought that please feel free to ask our speaker what kind of things you can pursue as you're heading off. I don't want it to be all sort of despair. I think the opposite of this is hope and what you can all do moving forward as young people getting your college education. So please ask what opportunities are out there, not just law school, but things related to the law, things related to civil rights, and to other opportunities that you might be able to seek out. So thank you all for coming, and thank you, John,